Tēnā koe te koka, mo tō mihi mai, koutou mā hoki, tēnā koutou katoa. Wow, first of all, a pleasure and an honour to be a part of Ako Panuku and their 2023 program. We are going to have a fairly tight 45 minutes whānau, so just bear with me while I get this up right from the start. We're just going to work through initially kapai. So why is it that we would look at provisions? Provisions of Te Tiriti o Waitangi whānau are initially what has occurred is that there's been a huge emphasis on principles over the last 3 decades, and there's been a few issues with principles. Kapai. So first of all, tiriti principles or treaty principles. These have allowed for a contemporary application and analysis of our treaties, right? Tiriti o Waitangi and the Treaty of Waitangi. But one of the challenges that we have with principles is that they're often used as a means to redefine what the actual provisions in Te Tiriti o Waitangi are. Now, in government documents, whenever you've heard them say Te Tiriti or the treaty, they sort of use those terms interchangeably. What they mean is the Treaty of Waitangi. What there's an emphasis on now, however, is to look to the actual provisions that are in the text, in both Te Tiriti o Waitangi and the Treaty of Waitangi. So what's really important to understand is that if you've ever tried to understand our two treaties as translations of one another, we've run into a whole lots of problems, whānau? And the reason why that is because they're not translations of one another. Many of you will already be aware of that. What they are two separate documents written for two separate audiences. And there are no errors in either of these documents, either Te Tiriti o Waitangi or the Treaty of Waitangi. There are no errors. All of those provisions within each of those texts are there to address particular aspirations and particular concerns of the day. So from this point, we're just going to have a look at what those provisions are. Just before we move on, when the principles first came about, whānau, so from 1975 onwards, the Waitangi Tribunal, right, is to investigate all breaches of Te Tiriti o Waitangi and the Treaty of Waitangi by the Crown from 1975 onwards. And so, of course, by 1975, we've already a lot of our land has already been taken. We're down to 3% in terms of our tenureship over our lands. And with regards to Te Reo Māori is on the brink of extinction by 1975, okay? And so all of these breaches of Te Tiriti o Waitangi that have had an impact on these two domains have already occurred. And so it takes another 10 years until 1985 when we have an amendment where historical claims are allowed to be brought before the Waitangi Tribunal. After that, 1986, the New Zealand government moves to privatise what are public assets in the, this is the, what's the name of the Blinken Act? Bear with me, whānau. It's going to come to my brain, right? In 1986, we have the New Zealand government moving to privatise all assets. And this is an issue, right? Because many of these assets that they're moving to privatise, things like railways, airports, old hospitals, all of these things are potentially subject to tribunal claims, historical claims. And so what the New Zealand Māori Council do is they take the New Zealand government to court and say, hey, this is going to be a breach of Te Tiriti o Waitangi or the Treaty of Waitangi. And in fact, your legislation states that nothing in this act shall permit the Crown to act in a manner that is inconsistent with the principles of the Treaty of Waitangi. Yes. And so what did the court say? Essentially what's happened in section 26 or section 27 of the Act, sorry, They give Māori basically 1 day to investigate whether or not we have interests in these lands and assets that they're about to privatize. And the New Zealand courts agree. So the courts agree with the New Zealand Māori Council saying, yes, New Zealand government, what do you think you're doing? You can't give Māori 1 day to investigate whether or not they have interests in these assets before you sell them off, okay? And so they had to go back and have a look at these things. And as a result, so this is what's referred to as the lands case. And there are a series of principles that come out of this. Prior to this, when you hear the Waitangi Tribunal mention principles, what they're referring to are the actual texts. But from 1986, we start to see the arrival of these new distinct principles that are supposed to be connected to the text and are supposed to take into account the spirit of our treaties, okay? In 1987, we have, actually 1988, we have another series of principles come out. Most of you would be familiar with these principles. They come out of a Royal Commission into Social Policy. They're generally referred to as the 3 Ps, okay? Partnership, protection, participation. And at the time, if you think in 1988, the notion of partnership was, what an awesome start to our principles, that we're actually going to give recognition to this idea that there should be partnership when it comes to decision-making and governance, particularly when it impacts on Māori lives, okay? Now, in 1989, what happened is that the Office of the Deputy Prime Minister, they come out with their own principles, right? And they actually say no to partnership. And their definition of tino rangatiratanga is that Māori, you have the right to organise as iwi, and under the law to manage your resources as your own, okay? So this is quite a different take. This is one of the challenges that has arisen with principles, is that some of them contradict each other. The Waitangi Tribunal are not the only ones to be able to make up principles. Anyone can come up with principles. My colleague and I, Veronica Tawhai, were doing a workshop with DOC, Department of Conservation, a couple of years back, and they shared with us 4 treaty principles, and 2 of them Ronnie and I had never heard of. Okay, so potentially anyone can come up with principles. This is one of the challenges with them. Besides the fact that so the Crown definition of tino rangatiratanga as a principle, for instance, is a perfect example of that they redefine what tino rangatiratanga actually means. So it's just important to be aware of that and to understand what the limitations of principles are and why it is we're not so much moving away from them, but this is the approach now. You should not be recognizing or identifying any principles that you cannot specifically link back to the provisions within the treaty texts, either to Tiriti o Waitangi or the Treaty of Waitangi. Okay, and in doing so, we avoid what a lot of people refer to as, when you think about principles in general, there are a number of challenges. One of them is interpretation. How I interpret the principle of equality can differ immensely from how, say, for instance, Papa Don Brash interprets it, right? The other thing about it is principles can be quite ambiguous. So where the rubber meets the road, where practitioners or teachers or health professionals or whoever it might be, public servants, where they have to operationalize these things and actually action them, they're not quite sure how to do so. So there's this ambiguity around principles at times that frustrates people into being able to, put forward initiatives and strategies, etc. So what we're going to do is have a look at what the actual provisions are and some of the recent evidence that has come from the Waitangi Tribunal, okay? Over the last 30 years, the Waitangi Tribunal has produced, a significant amount of evidence that gives us a clearer understanding as to, 1, what is in our treaties, and 2, why those things are in there. So we'll have a look at some of them, okay? So in Article 1, whether it's the Treaty of Waitangi or Te Tiriti o Waitangi, what is not disputed is that a level of authority is consented to. So rangatira consent to the Queen of England having a level of authority. The difference between the 2 texts is how much. It's how much, okay? In Article 2 of Te Tiriti o Waitangi, the again, it is about authority, but it's the authority of hapu and rangatira. And again, this is not, there's no dispute that this is what it is between each text. Again, the issue is well, what is the level of that authority? The other important point about Article 2 whānau is that often you'll hear people say that Māori rights come from Te Tiriti o Waitangi. This is a flawed view. And most of you would be aware of this. The Te Tiriti o Waitangi doesn't give us our rights. It simply reaffirms and assures us that these rights exist and that they will continue to exist into the future. Okay, and this is essentially what Article 2 is about. So Article 1, level of authority to the Queen of England. Article 2, the recognition of ongoing Māori authority. Article 3 is the provisions where we get something new, okay, Māori. We receive individual rights, and those rights are an extension of all the, in Te Tiriti o Waitangi, the rights and customs, the same rights and customs as her subjects, the people of England. In the English text, just a slight variation, it is all the rights and privileges are extended to Māori, okay? And Article 4, often referred to as the oral article, okay? Often when you'll do a treaty workshop whānau or tiriti education, many people leave out Article 4. I'm pretty sure that's because of Article 2 and the provision of taonga, and the feeling that all of those things in terms of Māori spiritual practices are already guaranteed or guarded as a taonga, okay? But as Te Atakura educators, we recognize and acknowledge it because it, the provision in here is, there is a provision in here that is for us all, everyone in New Zealand, and that is the right of religious freedom, okay? Religious freedom, but also ritenga Māori, Māori spiritual practices and customs are protected under Article 4, right? What we're going to have a look at, has anyone ever actually, one of the challenges we've had, whānau, is that there has been a really dehumanized view, particularly of our Māori ancestors, and that this dehumanization, when I say dehumanized, I mean it's when you reduce a people to something less than you so that you feel good about what it is you're doing, or not so much that you feel good, but you don't feel bad. Okay, and so in colonization, dehumanization is a really a central part of that process. If you think about our British ancestors coming over here, if they know they're coming to take another people's lands, this can cause internal conflict to individuals, right? If you see another person as equal to yourself, or another people as equal to yourself, and yet you go and help yourself to their resources, their lands, etc., then it's quite hard for you to live with yourself. And so the process of dehumanization allows for people to live with themselves in terms of that process of colonization, okay? And it just means they refer to it in the literature as it allowed for them to be able to avoid what they refer to as the moral conflict, okay, or the moral burden. So that being said, we have a number of myths that many of us have grown up with regards to understanding our treaties, okay? One of those is that, Māori, in terms of the reo, lack the sophistication to be able to articulate terms like sovereignty. Now, most of us, right off the bat, would have automatically recognize that, no, there's lots of words, in terms of divine authority that comes down from your ancestors and comes down to you. Yes, we have words for we have lots of words for this, right? So that's not quite the case. Not only that, there's been other myths. Māori, you just didn't know what you were signing and you signed it anyway, Has anyone ever, some of you may have heard this. Māori didn't understand what they were signing, but we signed it anyway, and what that relies on, whānau, is a really, again, that dehumanized view of our ancestors, that they would sign something, that they would give something to rangatira on the other side of the world, and they didn't know what that was, but they gave it anyway, We can't accept these types of explanations anymore, and of course, most of us within Te Ao Māori, and those of us who have grown up with treaty discourse in our homes, know this, okay? But for your average New Zealander, and basically public discourse, so all the public language around the treaty relies on these types of myths. And so it's just important that we recognize what they are so that we're able to actually just leave those things to the side and move forward with a proper analysis, okay? So just to give you an example, so one of those myths is that there wasn't the words. So what you're looking at here is, at the top, of course, is an extract from the preamble in Te Tiriti o Waitangi. Underneath is a current or a modern definition, translation of Te Tiriti o Waitangi, of that section from the preamble, and below is the corresponding preamble from the Treaty of Waitangi. So if we just have a look there, kia tohungia ki a rātou o rātou rangatira, tō rātou whenua, me tō rātou whenua, nā te mea hoki, he toko maha, he ngā tangata o tōna iwi kua noho ki tēnei whenua e haere mai nei. So all they're basically saying there is a recognition, okay? So in order to preserve our independence to us, because there are many of her subjects already living here. Now, whānau, when they say many in 1840, this is 2,000. Okay, so in our treaty, in Te Tiriti o Waitangi, they have recognized that this is many. In the Treaty of Waitangi, however, if you can see there, what is said, to protect their just rights, our just rights and property in consequence of the great number of Her Majesty's subjects who have already settled in New Zealand and the rapid extension of immigration, both from Europe and Australia, which is still in progress. Those are two quite distinct sentiments, whānau, and we have the words to be able to express rapid immigration. We have words for Europe and Australia at this time. So it's not the case that we don't have words. Okay? And this is I'm just putting this extracts up here just to exemplify what it is, that this is indeed a myth. Yes, we do have the words to be able to articulate these things. However, what would have happened if in the Māori text, Te Tiriti o Waitangi, what is expressed in the English text had been articulated? Well, of course, if our rangatira knew rapid extension of immigration, both from Britain and from Europe, yes, it's highly unlikely that they would have agreed to this, ka pai? But this is just one example in terms of that myth. The other predominant myths is that with regards to Article 1, whānau, and the provision of kāwanatanga, one of the predominant myths, and you'll still read this today, is that kāwanatanga was made up on the day. Okay, was made up on the day, 6th of February, during the drafts. Okay, so from the 4th to the 6th, that this term kāwanatanga was made up. Now, whānau, it only takes a surface investigation to realize how flawed this assertion is, that kāwanatanga was made up on the day. The very first religious text we have, okay, it's not quite the Bible, but it is a series of, so I think it's the first 30 books or first 20 books of Leviticus. There's parts of various epistles. There's a number of hymns, the Lord's Prayer, okay, the Lord's Prayer. These are all translated and published in 1827. The New Testament itself is completely translated by 1837 and published. So kāwanatanga is used right throughout those texts, and it's used to refer to a level of authority. Okay, so for instance, Pontius Pilate, for those of you Bible scholars out there, Pontius Pilate from the New Testament, the governor in Jerusalem, the Roman governor, he's referred to as the kāwana. Okay. If you do a keyword term search of the Bible in the reo, okay, you can get that up online now. Do a keyword term search of kāwanatanga. Kāwanatanga is in the Bible over 200 times. And this is, at least 2 decades before, in terms of that initial published religious text. This is 1837, so 13 years before Te Tiriti o Waitangi comes around. Another document where kāwanatanga is used is in, of course, he whakaputanga o te rangatiratanga. Okay? Declaration of Independence. Kāwanatanga is used in there to mean governor, governorship. So that completely shatters that myth that it's made up on the day. The other myth, whānau, is that the missionaries were rushed and they weren't that good with the reo. Whānau, Henry Williams arrives here in 1827. By 1835, he's helping to translate He Whakaputanga. So not only is he the primary, one of the primary interpreters into Tiriti o Waitangi, he's also one of the primary interpreters as far as He Whakaputanga is concerned 5 years earlier. But the missionaries also whānau were all reo speakers. When they're teaching the gospel to our tupuna, they're not teaching it in English. They're teaching in the reo. A lot of our missionaries are some of our early linguists, some of our earliest academics, some of our earliest translators. For instance, Thomas Kendall. Thomas Kendall assists Waikato and Hongi Hika in the translation of our first dictionary in 1820. Okay, that's not quite completed, the translation, until a bit later in Sydney, but it just goes to show our missionaries, whānau, and that claim that they're not that great with the reo, absolute rubbish, absolute rubbish. They know exactly what they're translating, okay, and they've used these terms before. So kāwanatanga refers to governorship or the actions of the kāwana, kāwana being a transliteration of governor. And how is it that we know about governors? Well, as early as 1805, actually before that, there has been a couple of rangatira from the north who got kidnapped. And they were kidnapped and taken to Sydney because the Europeans in Sydney assumed that they would be able to teach them how to use harakeke. And of course, when they got there, they said to them, oh, we're not kairaranga, we don't do harakeke, you've kidnapped the wrong Māoris, right? So Governor King has had to bring Nuku and his companion back to the far north and restore them to their lands. And in doing so, he treated them very well because he knew that trade and their development with regards to the use of harakeke depended on, having a good relationship with Māori, okay? But this is where we first meet a kāwana in Sydney, a governor. Sydney is a penal colony, and they have a governor there who is administrating English or British law for British subjects that are living in New South Wales. This is where we first meet a kāwana, 35 years before the signing of Te Tiriti o Waitangi. So we know what kāwanatanga means, whānau. This is the first provision in Article 1 of Te Tiriti o Waitangi. Now, why have we given it? Well, not everyone agreed to it. Not everyone agreed to it. But what kāwanatanga allowed for was a local administrator of British law to be in the Bay of Islands to keep all of those lawless British subjects in order. Now, we could keep them in order, of course, under tikanga and kawa, okay? And lots of examples of this whānau where we apply Māori law, Māori tikanga, where there are breaches of these, they are disciplined by Māori, these British subjects. However, because we have a developing trade relationship with Britain, and it's largely mutually beneficial, okay? It's mutually beneficial. It's probably not in our best interest to have to keep killing these fellas, okay, when they breach our laws. And there's a number of examples. Anyone from the far north who's on here, your Whangaroa and the burning of the Boyd, what happened to Marion de Fresnay at Muturua, even what happened to the New Zealand Land Company representatives and their militia that turned up to the Waido, okay? These are some examples of where we just discipline them ourselves. However, what kāwanatanga is, it's a really innovative approach that our rangatira have come up with. Hey, let's allow for them to have a kāwana here. There's only 2,000 of them. Let them have one of their rangatira here, which they call a kāwana, to apply their law to their people. Not everyone agreed with this, right? So there are a lot of rangatira that said, no. When we go to France, okay, when I go to France, I abide by French law. When I go to Britain, I abide by English law. When people come here, they should abide by the tikanga and kawa of Hapu, okay? So that was one position. Another position was actually there were a lot of Pākehā Māori living in our societies by this time, whānau. Some of us may descend from these people. These are Pākehā that have escaped Britain or that have escaped Sydney and are living as Māori within hapu. So they've assimilated into hapu life. There's a book written about them called Pākehā Māori. Okay, and on the cover is a Scotsman with a full face tāmoko. He has, responsibilities. He has occupation rights of lands. He's allowed to benefit from resources. He has several wives. This book is about those types of individuals, okay? So those ones aren't a problem. The ones we are having a problem with is the lawless ones. However, what Kāwanatanga suggests is that British law will be over British subjects. Now, if you imagine you're a rangatira and you've got your own Pākehā Māori, very useful to you, may have married some of your sons or daughters, may serve a particular role, especially when it comes to interpreting, okay, and establishing new trade relationships. And so the idea that a queen on the other side of the world would have authority over that person, many rangatira also didn't agree with this, okay. There were, however, over 530 signatures on Te Tiriti o Waitangi. Okay? So many rangatira did agree for the extension of Kāwanatanga to be given. This is the provision. In the English text, it is not Kāwanatanga that is given, okay. What is claimed there is all the rights and powers of sovereignty. Okay, all the rights and powers of sovereignty are claimed by the British Queen with regards to New Zealand. Now, whānau, this is really important. The English text is not present at any of our, it's not present on the 6th of February, 1840. It's not discussed. Its terms are not discussed. Okay, it is Te Tiriti o Waitangi and the terms of Te Tiriti o Waitangi that our rangatira are agreeing to. The English text, however, is for an audience. It's just not the Māori audience. The Treaty of Waitangi is for the international audience. So what England are saying here to all of those other colonists is, hey, we have sovereignty here now. And this is the provision in Article 1 of the Treaty of Waitangi. And whānau, sovereignty at this point, is not about an oppressive thing towards Māori. It is more of a protective mechanism for all of those other colonial nations out there who, for the last 400 years, have been going around claiming lands. What this Article 1 tells them is, hey, you're too late here. You're too late here. So it is a form of a protective mechanism. These are the two provisions in the articles, okay? So in regards to the authority, in Article 1 of Te Tiriti o Waitangi, the level of authority is that of a governor to be here, one governor, to apply British law to British subjects who are living particularly in the Bay of Islands. Bay of Islands, by this time, whānau has become known as the hellhole of the Pacific, hellhole of the Pacific. And so it gives you a little bit of insight into what's sort of happening up there. You've got all of these different seasonal whalers, sealers, traders coming in, and heaps of them are just behaving lawlessly. And so this provision allows us to address that. So keep in mind, whānau, both documents are problem-solving documents. We go on to Article 2. Article 2, te tino rangatiratanga is guaranteed to rangatira and hapu. Te tino rangatiratanga o rātou wenua, o rātou kāinga, o rātou taonga katoa, okay? Tino rangatiratanga is another one of those things where people say, oh, you know what Māori thought tino rangatiratanga meant. Whānau, it's a Māori word. Our rangatira knew what rangatiratanga meant. The missionaries knew what rangatiratanga meant. It's in the title of the Declaration of Independence to mean independence. This declaration has been recognized by the British Parliament. They know what it means. Okay. So this idea that rangatiratanga actually means something different, no. Tino rangatiratanga, one translation of it is the independence. Independence over our lands, over our homes, and over all of our treasures, both tangible and intangible. This is the other provision in Article 2 of Te Tiriti o Waitangi, taonga. Okay, so tino rangatiratanga and taonga, Article 2, Te Tiriti o Waitangi. The provision of taonga was defined by Papa Hirini Mokomead. He defines it as both tangible and intangible treasures, okay? Because for our For our Pākehā whanaunga, often they translate treasures as just tangible things, and in particular, property. Okay? But, of course, from our point of view and a spiritual point of view, philosophical point of view, we have many taonga that are intangible. They can't be touched, but they are definitely taonga. One of these things, of course, being our reo. Okay? The independence of our lands, villages, and all of our treasures is guaranteed to us. So it's not given to us. These things already exist. What Te Tiriti o Waitangi guarantees is that they will just carry on into the future, that they will not be impinged upon or impeded. In the English text, the Treaty of Waitangi, the provision is the full, exclusive, and undisturbed possession. This is our provision, okay? And this is one of the challenges, whānau, because people think that the issues that have arisen between Māori and Pākehā have arisen as a result of the differences between the two texts. Whānau, if we had just honoured the English text, we would not be in the position we're in today. The English text states, the full, exclusive, and undisturbed possession of our lands, estates, forestries, fisheries, and all of our properties. Now, if this had just been honoured, we would not be down to 6% of our land left, today. Okay, even after all the settlements, whānau, we're still only up around 6-7%. But what it does suggest is, first of all, it addresses a couple of issues. In Te Tiriti o Waitangi, rangatira are a little bit concerned. Okay, why are they concerned? Because by 1840, over 1,000 ngāpuhi have been to 69 different nations around the world. And what have they seen with regards to our British friends? They've seen some things that have made them a bit worried, particularly in Sydney. So during the debates at Waitangi, Taonui puts this question to the governor, Hobson: hey, how do we know that eventually you're not going to behave here like we've seen you behave in Sydney? Okay, and what he's referring to there is the treatment of Aboriginals. This is becoming an issue. Although we're developing this cool trade relationship with Britain, and there are some great things going on between us, we are a little bit concerned, okay, about the treatment of native peoples in other parts of the world. And actually, Taonui puts this to Hobson in that question. How do we know eventually you're not going to behave here like we've seen you behave? We hear all the wonderful things you're saying. And so here, whānau, our tino rangatiratanga, our independence over our lands, our homes, and all of our treasures is absolutely guaranteed. In the English text, it is the full, exclusive, and undisturbed possession. Now remember, in Article 1 of the English text, they have claimed sovereignty. In Article 2 of the English text, they therefore can't guarantee to Māori our independence, keeping in mind this is for the external world. If they say in Article 2 of the English text and Māori have their independence, then, the French, the Americans are more than welcome to continue having relationships with us based on a sovereign or on an independence basis, right? So they haven't put that in Article 2 of the English text, but what they have put in there is still very, very strong. Very, very strong. And what it does say to the rest of the world is, hey, you can't come here and behave like how we Europeans have behaved in the treatment of native peoples everywhere else. The full, exclusive, and undisturbed possession of Māori lands, estates, fisheries, forestries, all of these things is guaranteed. Okay. The last thing in terms of provisions there is in regards to land trades. In Te Tiriti o Waitangi, it simply refers to te hokonga, that Māori will agree to trade land with a representative of the Crown at a price agreed upon. Okay. In the English text, it is the right of preemption which is given, or claimed rather. And the right of preemption, whānau, basically means that the Queen or her representative has the right of first refusal on all land trades here. And how that plays out in the day is basically they're the only ones that can purchase land from Māori, because no one is going to purchase land from Māori if it is not recognised by the British Crown in terms of the title, right? So they're all going to go through the Crown. The right of preemption addresses issues with regards to the French. So there are some significant French interests, particularly in Akaroa, with the company Nanto Bordelais, who have been given permission to establish a colony in Banks Peninsula, in Akaroa. There's also an individual in the far north by the name of Baron de Tiriti, okay, who He's a humanitarian, and he's got these humanitarian views. He doesn't think that the really terrible impacts or outcomes as a result of Europeans meeting with native peoples, he doesn't believe that those terrible outcomes have to happen, and he thinks that he can create a society where natives, New Zealanders in this case, or aka Maori, and Europeans can live together in perfect harmony. And he thinks he's going to create this in the Hokianga, and that he is going to be the king of that. Okay, so these are the two sort of concerns that Britain are worried about, not Maori. Okay, Maori are not worried about the French. Okay, there is those in the far north. Okay, our Ngāpuhi whanaunga in the far north, there is some justification for them to have a little bit of concern about the French because of what happened with Marion de Fresnay in 1772, where he was killed. And then 2 years later, a French warship comes back and basically exacts their revenge on a neighboring hapu, okay, on a neighboring hapu in the Bay of Islands. The right of preemption means that any Europeans that are coming here, they can't just claim lands off Māori. And whānau, this is really important provision, in particular because Europeans are just claiming lands. So the likes of Edward Gibbon Wakefield, he's claimed something like 20 million acres of land. We only have 66 million acres. So he's claimed something like 20 million acres before he's even arrived here, let alone met the owners. Okay. There's a couple of brothers from Sydney who have claimed Auckland. Just these really frivolous, ridiculous claims. Okay. Now, back in the days, in places like in places like Australia, Europeans just did this. They just claimed massive amounts of lands, but you can't do that here because our people and our society are established. And our relationship with Britain is well established. These are the provisions, Article 2, whānau. Article 3, ngā tikanga katoa rite tahi. So the same rights and customs as her subjects, the people of England, are extended to Māori. This would have an appeal to Māori for a few reasons. One, we get access to all of those all of those trade routes, trade relationships that Britain already has established around the world. We now have access to those. We have access to the courts. So if we get to a foreign market and we find that our produce, in particular our wheat, is being undermined, we have recourse to the courts. We can go and live in England. Okay, I wouldn't put it past our rangatira to assume that we could have representation at Westminster in London as a result of this article. There's not much difference except in the English text. They've emphasized the benefit there in saying all the rights and privileges as opposed to the same rights and customs. So they've emphasized the benefits in terms of privileges. Why have they done this? Well, one of the competitions that's going on between France and England, whānau, is who is the more benevolent colonizer? Okay, who is the more woke colonizer? This has come about as a result of a humanitarian movement that swept through Britain. Okay, so they've ended the slave trade. They've ended slavery 10 years later. They've now got laws around child prostitution, prostitution in general, the treatment of women, all of these types of things. This sentiment has then eventually moved to a consideration and concern for the Aboriginals in the colonies. Okay, the way that Britain have behaved prior to this, they want to move away from this. And so we see this expressed in Article 3 of our treaties. Okay. What some people say, whānau, so for instance, you'll hear some people with an analysis. Now, I know we're about to come up to elections and you'll have all kinds of treaty analysis coming out of politicians, but we don't care who you vote for, but what we will criticize is treaty analysis. And often what people assert, particularly in particular right-wing parties, is that Article 3 is what makes Māori British subjects. Yes. Now, many of you can already consider what the arguments against this are. But first of all, whānau, if they wanted to claim that, they should have just said that. And of course, if they would have said that, Māori, you are now subjects to the Queen of England, of course, our rangatira would not have signed it. The other point is that you can't isolate one article of our treaties, whānau, and use and privilege that above the others. Because, of course, in Article 2 of Te Tiriti o Waitangi, our independence is absolutely guaranteed to us. Okay. So these are essentially our provisions. This is a really unique provision, radical at the time. Okay, really radical at the time. Just think, 20 years before this, finally, you can go to London and buy a black body on the streets. Now here we are. All the rights and privileges of British subjects are being extended to Māori. Okay, this is the only article in our treaties whānau where we get something new. Okay? But just keep in mind what those provisions are. Ngā tikanga katoa rite tahi, and in the Treaty of Waitangi, all the rights and privileges. Just conscious of the time, so I'm just going to get through the last article here. There are a couple of provisions here. Ko ngā whakapono katoa, so all the faiths. And at this time, of course, they're referring to Christian faiths, but the principle or the spirit behind this whānau would be, of course, that today, you know, all religions, all people here have the right to express and practice their religious freedoms, okay? Provided they don't impinge on other people's freedoms, right? This is the spirit of that. So ngā whakapono katoa is the provision. The other provision there, and you can see it highlighted, is te ritenga Māori. So our spiritual customs, practices are protected under Article 4 of Te Tiriti o Waitangi. So there's no difference between the two. This was recorded by Colenso, I believe it was, on the 6th of February 1840. It came about as a result of Pompelia, the Catholic bishop, who was a little bit concerned that because Māori were entering into a treaty with the British, you know, the experiences of Catholics in Britain leading up to this period of time was they were persecuted quite severely in Britain. So there has been an emancipation movement in Britain, and that is the emancipation of Catholics. And we see the sentiment come through in our treaty where Pompelia brings this issue up. Hey, can we make sure that religious freedom is safeguarded, please? And so the governor includes this and guarantees it. Okay? Whānau, these are the provisions of our treaties. Any principles that are recognized must be connected. You must be able to connect these to the provisions. Otherwise, they become what we refer to as fluffy, where you get these really fluffy treaty statements or fluffy treaty commitments by organizations that have no teeth. The teeth comes from your ability to connect them clearly and cohesively to the relevant provisions within Te Tiriti o Waitangi or the Treaty of Waitangi. Okay?